What is ADR? Alternative Dispute Resolution, ADR, is any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues. ADR may be arbitration, mediation, conciliation, early neutral evaluation, mini-trial, or any combination thereof. Arbitration. Arbitration means voluntary dispute resolution process in which one or more arbitrators appointed in accordance with the agreement of the parties or rules promulgated pursuant to this act resolve a dispute by rendering an award. Mediation. Mediation is a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. Conciliation. Conciliation is a process whereby parties request a third person or persons, the conciliator, in their attempt to reach an amicable settlement of their dispute arising out of or relating to a contractual or other legal relationship. The conciliator does not have the authority to impose upon the parties a solution to the dispute. Early neutral evaluation. Early neutral evaluation is an ADR process wherein parties and their lawyers are brought together early in pre-trial phase to present summaries of their cases and receive a non-binding assessment by an experienced neutral person with expertise in the subject, in the substance of the dispute. Mini-trial. Mini-trial is a structured dispute resolution method wherein the merits of a case are argued before a panel composed of senior decision makers, with or without the presence of a neutral third person, after which the parties seek a negotiated settlement. Good offices. Good offices are offices that essentially provide logistical support to parties to come up with consultation. It is merely the provision of venue only, and not the consultation itself. It is plainly administrative support. Benefits of ADR. Alternative dispute resolution ensures party autonomy on how parties settle their disputes. Parties can be creative in settling their disputes. Flexibility of proceedings. Confidentiality of proceedings. Reduced cost and time in the resolution of conflict. Less stress because it will avoid long litigation. Preservation of relationship. What laws govern ADR practice in the Philippines? Republic Act No. 9285, an act to institutionalize the use of an alternative dispute resolution system in the Philippines and to establish the Office for Alternative Dispute Resolution and for other purposes. Executive Order No. 1008, creating an arbitration machinery in the construction industry of the Philippines. Republic Act No. 876, an act to authorize the making of arbitration and submission agreements to provide for the appointment of arbitrators and the procedure for arbitration in civil controversies and for other purposes. Uncitral Law. The model law is designed to assist states in reforming and modernizing their laws on arbitral procedure to take into account the particular features and needs of international commercial arbitration. It covers all stages of the arbitral process, from the arbitration agreement, the composition and jurisdiction of the arbitral tribunal, and the extent of court intervention through to the recognition and enforcement of arbitral award. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and the different legal or economic systems of the world. Are there exceptions to RA 9285? Yes, according to Section 6 of Republic Act number 9285, it shall not apply in the resolution or settlement of the following: A. Labor disputes covered by Presidential Decree number 442, the Labor Code of the Philippines, as amended, and its implementing rules and regulations. B. The civil status of persons. C. The validity of marriage. D. Any ground for legal separation. E. The jurisdiction of courts. F. Future legitim. G. Criminal liability. H. Those which by law cannot be compromised. And I. Disputes referred to court-annexed mediation. What is OADR? The Office for Alternative Dispute Resolution, OADR, was created under Republic Act No. 9285, Alternative Dispute Resolution Act of 2004. It is an attached agency of the Department of Justice, DOJ, tasked to oversee the state of both public sector and private sector ADR. What is the role of OADR? The objectives of OADR are: 1. To promote, develop, and expand the use of ADR in the private and public sectors. 2. To assist in the monitoring, studying, and evaluating the use of ADR by the public and private sectors. And 3. To recommend to Congress needful statutory changes to develop, strengthen, and improve ADR practices in accordance with world standards. Powers and functions of the OADR. The powers and functions of the OADR are: 1. To act as appointing authority of mediators and arbitrators when the parties agree in writing that it shall be empowered to do so. 2. To conduct seminars, symposia, conferences, and other public fora, and publish proceedings of said activities and relevant materials or information that would promote, develop, and expand the use of ADR. 3. To establish an ADR library or resource center that will contain laws, rules, and regulations, jurisprudence, books, articles, and other information about ADR in the Philippines and elsewhere for easy access to the public. 4. To establish training programs for ADR providers or practitioners both in the public and private sectors, and to undertake periodic and continuing training programs for arbitration and mediation, and charge fees on participants. It may do so in conjunction with or in cooperation with the IBP, private ADR organizations, and local and foreign government offices and agencies, and international organizations. 5. To certify those who have successfully completed the regular professional training programs provided by the OADR or other ADR provider organizations as approved by the OADR. 6. To charge fees for services rendered, such as, among others, for training and certifications of ADR providers. 7. To accept donations, grants, and other assistance from local and foreign sources. And 8. To exercise such other powers as may be necessary and proper to carry into effect the provisions of the ADR Act of 2004, RA number 9285. For more information, visit our website at oadr.doj.gov.ph.